Have you ever gotten one of those notices from your homeowners association and just thought, wait a minute, who even made this rule? Well, we're going to dive into the story of one guy who didn't just ask that question. He took it all the way to a legal showdown. And trust me, it's a fascinating case that shows just how deep the rabbit hole of community rules can actually go.
And that really gets us to the absolute heart of this whole thing. The big question is, what happens when you sue your HOA for something a developer was the one who actually did? It sounds like a simple question, right? But the answer? Oh, it's like a masterclass in legal strategy and why it's so important to know exactly who you're fighting.
Okay, so let's meet the guy at the center of all this, Lawrence M. Wojtowicz. Back in 2006, he filed a formal complaint against his homeowners association. And this wasn't about, a fine for his lawn being too long or anything like that. No, he was challenging the very legitimacy of the board that was running his entire community.
To really get what Mr. Wojtowicz was so upset about, we've got to go back in time a bit. Because the source of this whole fight isn't just one thing that happened. It's a whole chain of events, of changing owners, and most importantly, some major changes to the community's founding documents.
And this all revolves around this key term, CC&Rs. That stands for Covenants, Conditions, and Restrictions. If you live in an HOA, this document, this is the law of the land. It dictates pretty much everything, from the color of your front door to how the whole association is run. It really is the neighborhood's constitution, and it is right at the heart of our story.
So let's just quickly look at the timeline here. The original rules, the CC&Rs, they're put on the books way back in 1985. Now fast forward to April 2003. This is the key moment. A brand new developer comes in and buys a massive chunk of the community at a bankruptcy auction. We're talking 228 lots plus all the original developer's special rights. Then just a year later, Mr. Wojtowicz, who had actually worked for the old owner, buys his own lot and even gets elected to the HOA board. And with that, well, the stage was set for a major conflict.
And here's why. The moment that new developer, the LLC, took over in 2003, they didn't just start building houses. Nope. The first thing they did was rewrite the constitution of Juniper Ridge. And the changes they made, they completely flipped the balance of power for the whole community.
And this is where things get wild. The new amended CC&Rs, they created two classes of voters. You had Class A, the regular homeowners like you and me. They got one vote for every lot they owned. Simple enough. But then there was Class B, which was just the developer, and they got 10 votes for every lot they owned. Just think about that for a second. One single entity with 10 times the voting power of any other resident.
And you can probably guess what happened next, right? All that voting power meant they could completely control the board. It was a 5-person board. And with their super votes, the developer could single-handedly elect 3 of them, giving themselves a permanent majority. The homeowners, well, they could only ever elect 2 people. The developer now had total control.
So Mr. Wojtowicz sees this whole setup and he's thinking, no way, this is not right. He was convinced that the developer's rule changes from 2003 were totally illegal from the get-go. So he decided he was going to do something about it. And that decision kicked off a legal battle that would take years to play out.
But, getting his day in court, that was a whole other battle. He filed his first complaint in September. The State Department kicks it back, says it's incomplete. So he tries again in November, kicked back again. He files a third time later that same month. This just shows you how persistent this guy was. He was not giving up.
And to give you a sense of just how personally he was taking this, get this. In a document he attached to his complaint, he didn't just cite legal codes. He quoted the 10 Commandments. He basically accused the developer of breaking a commandment, of coveting the community's assets for their own gain. I mean, this shows you this was way more than a legal squabble for him. This was a moral fight.
Okay, so what was his actual legal argument? Well, it was pretty clever. His lawyers pointed to the original 1985 CC&Rs. They said there was a clause in there that basically locked the rules in for a 30-year term. And based on a previous court case, they argued that meant nobody could legally change those rules until 2015. So all those changes the developer made in 2003, totally illegal, null and void.
But of course, the developer's lawyers fired right back. They said, no, the specific wording in our documents is different from that other case. And they also made a practical argument saying, hey, we've poured hundreds of thousands of dollars into this place. If you undo all our changes now, it's going to tank everyone's property values.
So you've got these two sides, both with pretty solid legal arguments. The case finally goes before a judge. Everyone's on the edge of their seat, waiting to see who's right about the rules. But the final decision? Yeah, nobody saw this coming.
So,
Who was right? Could the developer change the rules or not? Well, here's the absolutely incredible thing. The judge never answered that question. The entire case got tossed out before that main issue was ever even decided. And the reason why is a huge lesson in how the law works.
It all came down to one single, powerful legal concept: jurisdiction. Basically, jurisdiction is the official power a court or an agency has to make a legal decision. If you take your problem to a place that doesn't have the authority to rule on it, it doesn't matter how right you are. They just can't help you.
And that's exactly what happened here. The judge looked at the case and said, your complaint isn't really with the HOA. The HOA is just enforcing the rules someone else made. His real fight was with the developer, the LLC, that wrote those rules in the first place. He had sued the wrong party, and he did it in the wrong venue.
Case dismissed.
So after all that time, all that fighting, the main issue was never even settled. But wait, the story isn't quite over. In fact, this last chapter, this might have the most practical lesson of all for any of us living in an HOA.
See, after the HOA won by getting the case dismissed, they turned around and asked the judge to force Mr. Wojtowicz to pay for their lawyers. And we could be talking thousands and thousands of dollars here. I mean, he lost the case, so it seems obvious he should have to pay, right?
Nope. The request was denied, and the reason why is just incredible. The judge pointed to the community's own CC&Rs, the very documents they were all fighting over. The rules said the winner could collect legal fees in a court action. But this hearing, this wasn't a court action. Legally, it was called an administrative proceeding. And because of that one-word difference, Mr. Wojtowicz was saved from a massive bill.
So, what can we all learn from this absolute saga? Well, first, you've got to know who your fight is really with. Is it the people enforcing the rule or the people who wrote it? Second, know where to fight. The type of court or hearing is just as important as your argument. Third, every single word in your community documents matters immensely. And finally, even if you are 100% right, a legal technicality can shut your whole case down before it even gets started.
And that really leaves us with one final thought. While this was one man's fight in one particular community, the lessons here are universal. It really makes you think, if the rules where you live were suddenly changed overnight by someone with a lot of power, would you know who to hold accountable, and just as important, where you'd need to go to make your stand?